Ladies and gentlemen, welcome to OC Street Files Live, where the law meets the streets and the truth gets told loud enough for the system to hear it. I'm Bosco, certified paralegal, and tonight, if you know anything about me, you know I'm not just here to entertain. I'm here to educate, expose, and empower. So tonight we're doing something brand new, something that can literally help somebody get their freedom back. We're covering current, real, active Illinois Supreme Court cases that came back on appeal. Not old stories, not cold cases. These are cases happening right now in the state of Illinois. And listen, there's somebody sitting in a cell tonight who doesn't know they still have hope. Somebody sitting in the day room right now thinking their case is dead because the judge denied them 3 years ago. There's somebody watching this live who has a cousin, a brother, a father who thinks the legal system is a straight line. But here's the truth. The truth is that the legal system is a circle. Cases come back, motions get reopened, mistakes get fixed, science changes, procedures get challenged. And when the courts mess up, you can come back through the door. Tonight we're going to talk about 6 major cases that show that exact same thing. And let me say this on record. We're starting with Illinois, but we're going state to state. Indiana, Ohio, Michigan, Wisconsin, all of them. So if you want your state covered, drop your state in the comments. But tonight, Illinois is in the spotlight, so grab your notebooks, because again, this isn't just entertainment, this is education. The sky is in a live show. So here's what we're breaking down tonight. There's People versus McCoy. That's memory contamination, new innocence evidence. People versus Hammond, lawyers failing their clients under Rule 651C. There's People versus Reed, what it really takes to get a certificate of innocence. People versus Dobbins, can innocence claims continue after someone dies? That's the question. There are People versus Molina, cannabis odor in the police search loophole. People versus Cousins, that's the Safety Act. If you're from Illinois, you know you've heard about this. The Safety Act, detention rules, and who actually qualifies. And the goal tonight isn't to gossip about cases, it's to show you exactly how appeals come back, how mistakes get fixed, and how your people might be able to get another shot. And I just want to explain briefly how cases can come back. Before I get into the first case, let me break it down. A lot of people think appeals are one and done. Like you get one appeal, you lose, and it's over. No, that's not how it works. There are multiple entry points back into the court system. There's direct appeal right after conviction. There's post-conviction petition, arguing constitutional violations. Successive post-conviction, a second petition with new evidence. There's actual innocence claims. This is based on new science, new witnesses, new evidence. There's Rule 651C violations when your post-conviction lawyer or attorney screws up. There are certificates of innocence. After your conviction gets overturned, you'll get the certificate of innocence. There are remands. This is when the appellate courts send cases back down. There are appeals from remand, when a judge still gets it wrong. And there are statutory changes like Safety Act or cannabis laws. There are new procedural rules like changes in eyewitness identification law. Each of these is an open door depending on your situation. So when you hear these cases tonight, pay attention to the reason that they came back, because the same reason might apply to somebody you know. So this is docket number 131565, memory contamination and actual innocence. This is People versus McCoy, a case about eyewitness identification, memory, and science. And let me tell you something, nothing in the world is less reliable than a scared, stressed out eyewitness when cops are standing over him. And so I'll give you a little bit of the background. McCoy was convicted off eyewitness testimony, plain and simple. The witness said, that's the guy. No DNA, there was no confession, no physical evidence tying him to the scene. The kind of case we all know too well. We've heard about it before. Years later, research starts coming out showing that police lineup procedures used in his case could have contaminated the witness's memory. Not intentionally, but the process itself creates false certainty. And so let me break this down in terms that we can all understand. Your memory is not a video camera. It's a folder on a mental hard drive. And every time you revisit the folder, you rewrite part of the memory. So if a witness sees a lineup, then sees the face again, then hears officers say, take your time, then gets shown photos in a certain order, then sees the suspect in handcuffs later, their brain slowly convinces them that this is the person, not because they remember, but because the system nudged the brain in that direction. In Illinois, to file an innocence claim, you need new evidence that's material, non-cumulative, and likely to change the result at trial. The question here is, does new science count as new evidence? McCoy says yes. And why this came back, the lower courts said we don't think memory science counts. But the Illinois Supreme Court said we need to look at this again because the law is starting to recognize that eyewitness testimony is the leading cause in wrongful conviction. And we have real world examples. You might have heard about the Central Park 5 eyewitness pressure. Gary Dawson, there was a faulty ID. Ronald Cotton, mistaken identity, it changed a whole man's life. All overturned based on bad eyewitness ID. How many of you watching right now know someone who got identified wrong? Drop a 1 in the chat. This case is so important because if the Supreme Court sides with McCoy, it opens the door for anyone who got convicted off of shaky ID. So what I want you to get from this, if the police lineup was suggestive, if the witness changed their story, if they repeated lineups, if the witness only got confident after police involvement, your loved one might have an open door. All right. Next one here we have, this is People versus Hammond, docket 132-067, bad post-conviction lawyers and Rule 651C. Now, I know that this applies in Illinois. I don't know if it applies in other states. But anyway, this is where we talk about how lawyers fail their clients. Hammond filed his post-conviction petition, the thing every inmate eventually does at some point in time. And the lawyer he got assigned dropped the ball hard. He didn't amend the petition. He didn't talk to him. He didn't investigate. He didn't certify proper compliance under Rule 651C. Rule 651C basically says, if you're a lawyer and you're helping with a post-conviction petition, you must consult with your client, read the full record, make amendments to properly shape the claims. If they don't do that, the whole petition is invalid. And this matters because a lot of people have a family whose petition got denied, but they never realized the lawyer messed it up, not them. So the appellate court, this is how this came back. The appellate court said, we think the lawyer did fine, but the Supreme Court said, again, we need to take a closer look because if Hammond is right, the entire petition might have to be redone. And this happens countless times, countless cases. Lawyers submit petitions with typos. Lawyers never correct claims. Lawyers don't investigate. They ignore affidavits, and the inmate suffers the consequences. So if your loved one's post-conviction attorney never visited them, they never amended anything, they didn't include new claims, didn't attach affidavits, didn't correct trial errors, then a Rule 651C violation might get them back into court. Just keep that in mind. Again, that's Rule 651C. And again, I'm not sure at this moment if it applies in all states. I will get back to you on the next slide. The next one up we have is People versus Reed. And this is docket number in Illinois 130-595, a certificate of innocence. And this is where we can talk about getting paid when the system screws up. Pretty much, you beat your case. You overturn your conviction, you walk out the doors, but you're not done. You can file a certificate of innocence, which allows you to sue the state and get compensation. And I have something interesting about this, and I'm going to talk about it. It's actually going to be on my YouTube, OC Street Files on YouTube. It's interesting how they actually, anyway, the trial judge denied Reed's certificate, saying he didn't meet the requirements. Reed, of course, argued that he did, and now the Supreme Court is deciding what rules really are, what the rules really are. To get a certificate, you need to prove first that you were convicted. Your conviction was reversed. You didn't contribute to the conviction. You're actually innocent, not get guilty, but actually innocent. And this case matters because judges across Illinois apply this differently. Some judges make it impossible. This particular case could standardize the rule and help people who were wrongfully convicted finally get their money. I have about, I think about 2 or 3 more cases here. The next one that I'm moving to is People versus Dobbins. This is innocence after death. This is one of the saddest and deepest cases tonight. Dobbins fought for a certificate of innocence, and what happened, he died in the process. And so the question becomes, does his innocence claim die with him, or can his estate continue the case? The judge dismissed the case because Dobbins passed away. His estate appealed, and now the Supreme Court is deciding whether families can continue innocent claims. This really matters because there are families who lost everything, years, health, time, sanity, because their loved ones were wrongfully convicted. And when the person dies, the state says, oh well. This case is about dignity, about legacy, about families finishing the fight. So eventually I'll get back to you and let you know how that one turned out. Now this was an interesting one, and I know a number of people this will pertain to, so I will pay attention here. People versus Molina. This is 2024 IL 129237. Cannabis odor and vehicle searches. And this is pretty much traffic stops. This guy Molina gets pulled over. The police claim they smell cannabis. They search the car. They find contraband. The appellate court suppressed the evidence, said the search was bogus. The Supreme Court reversed it, said the court needs to look at it again. Pretty much police use the "I smell weed" excuse more than anything else on earth, right? The question is, since cannabis is legal, at least here in Illinois, does the odor still justify a search? What this case will do is define that rule. If smelling weed is not enough, thousands of searches across Illinois become illegal, right? Thousands of cases become illegal. And lastly, really quick, this is the Safety Act. Everybody's dealing with the Safety Act. This is People versus Cousins, 2025 IL 13866, Safety Act and detention rules. Cousins was detained. He argued that he should have been released under the new law, the Safety Act. The appellate court said no. The Supreme Court said that they messed up the analysis. So judges across Illinois are misapplying the Safety Act. This case forces them to follow rules, right? And that's what you want. You want some kind of standards that they have to follow, so that you're aware of what's going to happen in your particular situation. So again, tonight was Illinois. Next week, we're going to go to Indiana and get some of these cases together. Like I said, we're going state to state, breaking down appeal pathways, wrongful convictions, and second chances. This is OC Street Files Live, where the truth gets told. I'll see you guys next time. You have a great night.